Okay, so we've got a good number in the room, just a few more joining as I'm speaking. So what we'll do, we'll make a start, and hopefully those that join us won't miss too much of today's webinar. Today's webinar is the first of several in a series that will continue all the way through to the early part of 2024, with the common theme being around data privacy, data protection, and cyber security. And today's session will focus on the GDPR and data protection and a 5-year journey, hosted by myself, Richard Jackson, and my colleague Megan Mirza. Just a bit of an overview about Moore ClearCom and where we fit into the Moore Kingston Smith picture. So we're part of Moore Kingston Smith, the top 10 accountancy firm, as I'm sure you're aware, and we provide specific expertise and awareness and consultancy in respect of data protection and cybersecurity. We specialize in some areas such as education, charities and non-profits, but our clients come from across all sectors and professions. Our data protection officers in particular have great experience in respect of charities, governments, departments, police, justice, private sector and global entities as a whole. And you can see a range of our services on the screen on the right hand side in terms of what we offer as an organization. Many of our clients now, as I'll talk about during today's session, take a very balanced service from us. So they may have a data protection service and some cybersecurity support as well. Sometimes they might come to us for just one of these services, but increasingly it's a broad spectrum of different services. So today's session, what we're going to be talking about is data protection and how it's evolved over the last 5 years, since that kind of pivotal moment in May 2018 when the GDPR came into force across Europe. We're going to be looking at the legislative changes and their impact on how we operate and do business today, the consequences of data breaches in respect of the Information Commissioner's Office here in the UK and how civil claims play a part, the global impact of the EU and now UK GDPR, how the hybrid approach to privacy and security has evolved over the last 5 years and how we've seen that, and the impact directly and indirectly of COVID-19. We're going to talk about ESG and privacy and security and how the next 5 years might look. And this quote from OneTrust, I think, reflects the theme of what we'll be talking about today in terms of compliance or GDPR compliance or privacy being a one-time task. They're absolutely not. It's an ongoing activity and theme. Just some housekeeping before we start. Please use the Q&A function if you do have any questions during today's session. If possible, we will respond to questions during the session, especially where we feel they're relevant to something we're talking about at that specific time. If not, we guarantee that all of your questions will be answered after the event and we'll provide them as part of a summary document with a copy of the slides. It's the first of a series of webinars, as we said, focused on privacy and security. And the next one, we're going to give people a break during the August summer holidays. Once we get past this one, next one's 28th of September, where we'll be talking about cybersecurity and risk and how likely an attack might be. So before we move on to the first slide, slides, just a bit about ourselves. I'm Rich Jackson. I'm the Partnerships Manager at Moore ClearCom. My role is quite wide-ranging, so it ranges from developing channel and strategic partnerships, business development. I speak a lot at events and webinars and also podcasts. I'm really proud to be part of the Moore ClearCom team and what we do for our clients. And I'm joined today by my colleague, Megan Mirza. Megan, if you could just give us a bit of a brief overview of your background.
Yep, morning everyone, and thanks for joining us this morning. My background, so I've been at Moore ClearCom for about 18 months now, and I'm a data protection advisor, data protection officer working with charities, organisations, businesses in the UK, but also further afield, America, and a lot of global entities, so cross-border transfers and all that sort of interesting stuff comes into play. Prior to that, I worked in central government for a short time, supporting the data protection team in the Ministry of Justice. And then before that, 12 years at the Information Commissioner's Office, working for the Information Commissioner. So through that and my experience on the ground, so to speak, I have a good understanding of areas of risk and where organisations really should be focusing in terms of processing personal data. So we'll drop into some of that as the session goes on. So that's me.
Thanks, Megan. So we've got some really informative slides today, but we won't be using the slides as a kind of constant. We will be definitely looking to freewheel and unscript our conversation throughout, drawing on our professional and personal experiences and how we've maybe been affected even in the home as in our personal lives by some of the things we'll be talking about today. And where possible, we'll make some predictions about how we see the next 5 years or beyond shaping up, considering how much has changed in the world since we all started talking about the GDPR for the most part in the early stages of 2018. So Megan, could you maybe talk us through the journey so far to where we've got to today?
Yeah, and I have really just started from 2002. Data protection in the UK, we had our first act back in 1984, for those of us can remember that. But I've just brought it more up to date, otherwise we'd be here for a long time looking at the changes over time. So we had back in 2002, and you'll know the difference between a directive and a regulation. A directive, when it's issued in Europe, can be implemented in each member state in its own legislation, whereas a regulation comes into force as it is. So that's the distinction between the two. So back in 2002, we had a European direction, the e-privacy directive as it's known. And in the UK, we embedded that into our legislation through what is known as PECA, the Privacy and Electronic Communications Regulations. And I've just brought into play that legislation because it does interweave with the data protection. It is part of the framework of data protection legislation in the UK. We had a data protection directive, which was back in 2005. 1995, I should say, and then that led into the 1998 Data Protection Act. And the only change we've seen from 98 was the new GDPR coming into play. So there was a huge period of time where the legislation just became out of date, and it was clear, both in the UK and the EU, that we needed to move on and bring into play more provisions to cover the changing world in terms of tech and other developments. So in 2018, the GDPR, which was a regulation, came into effect in all EU member states, as the UK was part of that at the time. But we also had the Data Protection Act coming into play in 2018. And most countries, if not all countries within the EU, have their own data protection legislation that sits alongside the GDPR. And that's for locally exemptions and stuff like that, where each country is slightly different. And so they have their own legislation to sit alongside the GDPR. But primarily, it's the GDPR that you should be focusing on in terms of how we and should comply with the legislation. From Brexit, we've now moved away from the EU and we have the UK GDPR. It is essentially the same as we are at the moment. The article numbers are the same, everything is the same. There are some slight changes and differences, but broadly speaking, it is the same. But we will in the UK be moving away from that, more so with the Data Protection and Digital Information Bill, which is going through Parliament at the moment. And there will be some fundamental changes coming in as part of that legislation.
It's interesting, isn't it? It strikes me, and it struck me at the time when we think about the previous act being in 1998, which is, I think I'm right in saying, sort of 5 or 6 years after we started using the internet, and the internet was introduced and unleashed on the world without any kind of guidelines, and you could go online without any understanding of, I don't think anyone had an understanding of what it might become. And it was then a further 20 years before any kind of legislation was updated to reflect that evolution of the way that we were living and doing business. So I was on a webinar yesterday, and I think one thing that really struck me was that we might see more evolutions of bills and acts on a more regular basis, because to keep pace, I guess, with the pace of change. So in terms of the future, just very briefly, I know we're going to touch on it in more depth later in today's webinar. So this is what's going to happen next, I'm guessing.
Yeah, true. So in the EU, we're going to see the new e-privacy regulation, as it's called, which covers marketing, it covers cookies, all that type of processing. That will sit along the EU GDPR, so it'll be another sort of piece to the jigsaw in terms of the framework of data protection legislation. But in the UK, that won't apply in the UK. PECA will continue to apply in the UK, although there's some amendments coming through with the new data protection legislation. So really in the UK, we will still have the privacy and electronic communication regulations, PECA, that will sit alongside UK GDPR. And then in the EU, you'll have EU GDPR and the EU privacy directive. The privacy regulation. So they're all broadly similar in terms of the requirements and stuff, but you just need to be mindful that the UK is different and is moving away from the EU in terms of legislation and the approach around some stuff like AI.
Yeah, and AI we're going to touch on in depth as well, aren't we, as we go further into today's webinar. So this slide kind of reflects, I think, where a lot of organizations were. I mean, obviously in your role at this time, Megan, you would have been in the kind of thick of it in terms of shaping how this stuff might look. And I was in a commercial perspective working for an organization that was trying to navigate its way through what we needed to do. And it was panic. There was an awful lot of confusion. It seemed that all we were talking about as an organization was gaining consent and what that meant. We didn't, we're talking about January, February of that year. We didn't really understand the depths of lawful basis, etc. So was this what you experienced in terms of what was coming at you?
Yeah, so it was to a certain extent panic and confusion. I was in the ICO at the time and I was working on the bill team. So we were looking at the Data Protection Act, or the bill as it was, and it was very much up to the line in terms of getting that through Parliament and passed. We would often get sort of text sent to us as part of the draft bill very late in the day, so Friday afternoon, and you'd have to look at it and think about how it's going to work in practice and get back to the government colleagues really quickly in terms of the drafting. So it was drafted very quickly in terms of the Data Protection Act. And so that's why it's quite complex, a complex beast, I would call it, in terms of cross-referencing and stuff like that. So I think the new legislation is a way of tidying up some of these drafting issues. So it is really complex in terms of the way it was drafted, but it was also, just from a practical point of view, it was this one size fits all concept. So small and medium organizations were really struggling. They're the ones that were really coming into us with lots of questions about how do we implement this in practice? What's a ROPA? What's a record of processing? Quite basic stuff in terms of trying to get this framework in place. Do we need a data protection officer? Can we outsource it? That type of thing. Guidance. We were literally drafting guidance as the legislation was coming out, and in some respects just really rewording stuff to make it a bit more simpler for people to try and comply with it. So it was a very busy time, and because of the issues being raised by smaller and medium-sized organisations, the ICO then ended up doing quite specific guidance for them. And there's some leeway with the new legislation around catering for that approach, in terms of different organisations need different things depending on the size. So it was an interesting time to be at the ICO with the change in legislation, but it was very, very busy and chaotic to a certain extent as well.
I guess on the other side, it was the deadline, I guess, almost presented this false line in the sand that you would need to reach a certain state, if you like, by 25th of May 2018, when actually privacy is all about behaviours, isn't it? It's all about a constant, and it's about developing a privacy-based culture, whereas really at the time it was all about getting a privacy notice updated and as I said earlier, talking about consent and your lawful basis, and it was not practical in terms of how you might behave going forward. It was all about, by this date we need to have these certain things in place, and through that I think there were a wide range of common myths, mistakes and misunderstandings. I was really worried I was going to get those 3 M's out in one go, and I've done that. So I think what we'll do, we'll pop these up on the screen, Megan, and then you can respond to them as an experienced DPO. So the first one we heard a lot was that the GDPR is only applicable in the EU. Bearing in mind we're talking about 2018. Yeah.
So again, that was a myth and lack of understanding at the time, but it applied equally in the UK as it did in the EU. So that quickly became clear that it did apply here, as it, equally as it did in all the other member states, as we were at the time.
If you were a non-member state, so a business in Canada, for instance, that was dealing with an organisation suddenly after the 25th of May of that year, how would the GDPR have affected you?
And again, that was a really challenging time for organisations in companies outside of the EEA, let's say. So they needed to understand how international transfers worked and all that sort of thing. So it was a complex piece, and it's still a challenging thing for organisations that work outside of the EU and the EEA in terms of how they engage with businesses within the EU or the UK itself. So it is still a difficult area in terms of international transfers.
Okay, so we've got a little question. We're going to sort of jump in as we've got the one. Questions come in. For our wording in internal policy docs, should we use UK GDPR or DPA 2018? For example, this privacy policy is written in line with the UK GDPR or DPA 2018.
I mean, you can refer to both. I primarily would refer to UK GDPR because that's where you get all the legislation, the lawful bases laid out, the principles, all the main core bits in UK GDPR in terms of compliance. So I would tend to refer to UK GDPR within policies.
Okay. Yeah, I see quite a lot of privacy policies where they mention both, and I guess that's playing safe. Yeah. Okay. So, so our next common myth or mistake: we need consent to lawfully process personal data.
So consent is a really interesting one, and even now you see stuff on LinkedIn talking about we must only rely on consent. In data protection terms, there are different legal bases that you can rely on. Consent should be the least attractive one in terms of necessary processing. So if you are doing processing within your organization that's necessary for your purpose, then consent really is not the basis you should be looking to rely on. Consent is a really tricky one. It has to be freely given, fully informed. It can be withdrawable. So if you are doing some new processing where you're going to rely on consent, you need to factor in that actually people may not consent to this, or they may withdraw their consent. And so it can be quite a messy legal basis to rely on. So you really should be looking at the other bases that are in the legislation to make the processing sort of easier, I guess, in certain ways to take it forward without the worry about whether someone might consent or not. You still have to be transparent with people. People still have the right to object, so they still have their rights there, but consent is just a difficult legal basis to rely on for a lot of processing.
Yeah, okay. And if anyone has a question at any point about lawful basis and if they're unsure about the lawful basis they should be applying, please feel free to contact either one of us direct. Every organisation should have a data protection officer.
So again, that's a bit of a myth. There are mandatory requirements for some organisations to have data protection officers. So public sector bodies have to have a DPO. If you're doing large scale sort of surveillance, that type of thing, or particularly sensitive processing on a large scale, you should have a data protection officer. But what I would say is most organizations should have some sort of data protection expertise. So it doesn't need to be an officer as such if you're not mandated to have one, but you should have someone that is across the legislation and able to advise if you are an organization processing personal data.
Okay. And this is an interesting one because bigger organizations also comes up in conversation when we talk to clients about the cyber threat that's presented to them. In this instance, we're talking about the GDPR only applying to bigger organizations.
So no, it applies to any organisation that's processing personal data in the UK GDPR. And same with the EU, it applies across the board. And that's why the regulator has such a challenging task in any country, because you are essentially, you have oversight of nearly every organisation in the UK around processing personal data. Where there's a distinction between size of organisation, you tend to see that in other countries. So America, in the way they've embedded their legislation in practice over there, and we'll talk about that as part of this presentation. But here, no, it applies to any organisation processing personal data.
Okay, and when we come to some stats on how Spain issues fines under the GDPR, we'll see that they definitely have got to grips with the fact that it does apply to all sizes. Every data breach needs to be reported to the ICO.
No, again, that's another myth. And certainly at the time that the legislation came into play, they were absolutely swamped with breach reports going in, because people hadn't really got their heads around that actually it's only the really serious stuff that needs to get reported.
I heard a stat, I heard a stat at the time that for every 3 breaches that are being reported, only 1 actually needed to be. Is that about right?
That probably is about right, because they were absolutely swamped and had to put together another team just to cater with the number of breaches coming in, because this was the first time it was mandatory to report breaches with the new legislation. It was always a choice before that. So here it's mandatory, but as I said, it's the really serious stuff that needs to get reported and must be reported within the reporting time frame of 72 hours. So it's not every data breach. You often see stuff that might be potentially serious for, one individual or something, but that doesn't necessarily mean it needs to be reported. So there's definitely a weighing up and decision-making process that needs to come into play if you have suffered some sort of breach to make sure that you're not reporting unnecessarily.
Sure. We've already kind of touched on this, I guess. It's not a one-time exercise, is it? No,
it's an ongoing compliance journey, I would call it, where you keep everything under review, reviewing policies, procedures, doing annual training for staff, that type of thing. It's a live process that should be flooding through your organization and the culture of your organization. So yeah, it's not just a one-time thing. You've got your policies in place and we're all right, Jack, because it just doesn't work like that. No. And if there is an incident, the first thing you'll be asked is, when were your staff trained and how up to date are your policies?
Yeah, and the GDPR no longer applies post-Brexit.
So we've touched on that. So in the UK, it's the UK GDPR. So we have legislation and it will be changing, but yeah, it's the same. So Brexit really hasn't impacted on that apart from changing the name of the legislation.
Okay, so worth briefly touching, I think, on cookies, because it's something that if you're an organisation that has a website, which most organisations do, they'll be aware that they would be displaying their privacy notice or privacy policy, for example. They'll also be aware about how cookies come into play. From the, I won't read the slide out, but from the perspective of data protection and privacy and the GDPR, for instance, how do cookies come into play? Or is that more of is that a PECA thing, or is that a GDPR thing?
So cookies, the legislation around cookies is covered by PECA. In terms of data protection and PECA, it's really just important to think about transparency. That's sort of a theme and thread running through all this legislation, is transparency and no surprises. So making sure people are aware of what you're doing. So cookies is a bit more challenging in terms of being transparent with individuals in terms of how they work. You'll all be aware mostly that they drop onto your device when you go onto an organization's website, and there are different types of cookies. For non-essential cookies, so analytical cookies where you might be looking at what someone does on your website, whether they click on any links, that type of thing, or how long they stay on your website, you must have consent to use those non-essential cookies. And you must have that consent before someone starts navigating around the website. And so most organizations use a cookie consent management banner, so a cookie banner that pops up, and you should have the choice of either accepting or declining the use of those non-essential analytical cookies. And this cuts across through to using tags in email. So a lot of marketing software platforms can embed sort of pixel tags into email. So if you're doing a marketing campaign, you can tell whether someone's actually looked at the email communication, and whether they've clicked on any links in the email, that type of thing. So all of this is really around sort of looking at people's behaviours and analysing that. And so that's where the link comes into data protection. And it's important then, as it is with cookies, with the tags in emails, etc., that you have people's consent to do that and that you're transparent about it. So you're telling people that you use this type of technology. And that's really important. So your privacy notices or your privacy policies that go up on your website should cover this, or your cookie policies if you have a separate one. So a non-compliant website would be one where it doesn't have a banner coming up at all, or the banner doesn't give you an opportunity to decline. So if you don't want those cookies dropping, you should be able to do straightforwardly click on a decline button. and that would be the end of any of those non-essential cookies dropping. Not everyone's got this right at all, and it's probably not the most exciting part of data protection legislation, I would add, but it is low-hanging fruit for the regulator, and the regulator does take action in relation to PECA offences. And
it is very easy, I think, it's very easy and quick, isn't it, to check whether a website is compliant in respect of cookies.
Yeah, so that's the background. It's about being transparent. It's behavioural, sort of looking at people's behaviours around what they do on websites or with emails, etc. And so it's important that you have consent to do that, and that you have some consent management thing. So it's mostly going to be a banner with most organisations.
Brilliant. Thanks, Megan. And if anyone has any questions about cookies and wants to go into a bit more depth, or you're concerned that your site might not be compliant, please, again, just reach out to us and we'll be more than happy to help. We often get asked about the consequences of data breaches in terms of what is the actual consequence, what is the impact on your organization during and after, short or long term, from a data breach. So we thought we'd cover a little bit about that in terms of the Information Commissioner's Office, civil claims, and also we'll touch on reputation and the impact of reputation. So the Information Commissioner is appointed by the King on the advice of government, and currently is John Edwards, who's been in the post from 2022. I think Elizabeth Denham was the previous ICO.
Yeah.
And he himself personally is the regulator, supported by a team around him. So he's got these powers, Megan. So how might the ICO use these powers, and how do we kind of see this manifesting in reality?
Yeah, so significant powers, and really all I'd say is if you get any correspondence from the ICO, or if you have someone that has complained to the ICO about your processing, you need to deal with that. You can't just put it in the too hard box, because they do have significant powers. So an information notice, they can literally request information from you, and you have to provide that on the back of an information notice. An assessment notice would be potentially a non-consensual audit, so they could literally tip up on your doorstep and say, we're coming in to do an audit. And if they found practices that weren't great in terms of data protection, that could then lead to a fine. I mean, it's unlikely, but that is a potential there with a non-consensual audit. Enforcement notice is where they can require you to do something. So, for example, if you have a backlog of subject access requests that haven't been dealt with within the timescales, they can require you to complete those within, say, 6 weeks or something like that. They also have powers to actually stop you processing. So for a small organisation, if your processing is deemed to be or found to be unlawful, they could literally stop you processing. That could knock someone out of business. So they do have significant powers. Penalty notices, the fines and reprimands and that type of thing. So they have those powers as well. But they also have criminal investigation powers. So there is a criminal investigation team that sits there. There are criminal offences in the data protection legislation, and they have powers of entry and inspection as well. So really the message from me is don't ignore an ICO letter if you get one, because they do have those powers.
So we'll get into some hard numbers, and we'll look at the UK, Europe as a whole, Spain in particular, because of the reasons why you will see why that stands out, and also we'll focus a bit on Ireland, because Ireland has its own specific challenges due to the nature of the organisations that reside there. So in terms of the UK and our trends, fines, penalty notices issued by the ICO, 13 fines issued since May 2018, which only represents about 0.6% of the total fines issued across Europe. I think that the only message from Elizabeth Denham, the ICO at the time, was that they were looking at education and awareness as opposed to financial punishment. Megan, that was the kind of theme, I think, whether that has been effective or not in terms of generating a feeling of consequence for not managing data correctly is open to debate. The ICO is one of the lowest fining in terms of regularity bodies in Europe, although it does have some significant and notable fines, as we can see with the British Airways fine, Marriott and TikTok, etc. at the bottom. Megan, what's your view on the fining trend that we've seen in the UK?
So you're right, it definitely stemmed from Elizabeth Denham's time as Commissioner, and it was more carrot rather than stick approach. So having the guidance out there, we had a relationship management service that was purely there to encourage organisations to comply and provide support and stuff like that. So it was very much a pragmatic approach to helping organisations. One of the areas that they will take into account when they're fining is that you knew or ought to have known. So where there's a flagrant breach of the legislation, that's where you're likely to see the fines coming out. But where organisations have tried really hard to do stuff right, and something has just gone wrong, that will certainly be taken into account. And it will also be taken into account whether it's a charity or a big multi-global organisation such as Marriott, for example. So there's a lot of factors that come into play. Someone's just asked a question in the chat about what is a serious breach. I'm just going to touch on that before I go into reprimands. So when you're talking about serious breaches that are reportable to the regulator, you're looking at the potential harm or damage or actual harm and damage that might arise from whatever has happened. There was a lot of breaches within the Ministry of Justice, for example, where information about people in safe houses, so victims of domestic abuse, etc., their addresses had accidentally been given to the offender. This is all in the public domain. And it's those where you've got to get people moved from their houses, from their safe houses, because the perpetrator knows where they're living. So those sort of breaches where there's a real risk of harm to people or actual risk of harm and damage, that's where you're sort of talking in the higher levels, and where you need to be thinking about reporting. And it may only be one person affected, but it could be that serious that it is reportable. But there's quite a lot of guidance there in terms of how to make that decision in terms of whether it's reportable or not. So you're looking at the numbers of people affected, but also the type of data affected as well, or impacted by whatever's happened.
That's really useful.
So what we're seeing an increase in is reprimands as opposed to fines. I think the Commissioner has recently said that his approach is, or his preference is not to fine the public sector because it is deemed to be just going around in a circle because the money goes back to the Treasury. But we are seeing some really serious cases where reprimands are being issued now, but previously they would have been fined. A couple of recent examples. In fact, there's some examples this week, and I'll just touch on those as well. An NHS body in Scotland has just been reprimanded for using WhatsApp inappropriately to share patient details and stuff like that. There's been a couple of organisations in Northern Ireland that have been reprimanded for email issues, so where they've accidentally used the CC rather than the BCC function and stuff like that, divulging potential sensitive information to the recipients. Here we had some quite serious ones on the policing side where an app was introduced to do with phone calls, but it was actually recording phone calls without people knowing about it. So it links back to that transparency point. The personal data not being disposed of properly at the Ministry of Justice was an interesting one where, and I was there at the time that this was reported, where bags and sacks of paper documents were left out. I think they were going to be shredded at some point, but offenders, prisoners, etc., inmates had access to the information, but it was all staff records. So it was HR records and stuff like that. So some really sensitive stuff in there. They were reprimanded for not disposing of personal data properly. Thames Valley Police, another policing one where they hadn't redacted information properly and the names and addresses of witnesses were divulged to the accused. So lessons learned, the ICO have just reported on this. So what is really important is, we've talked about this, is implementing policies, training, and embedding sort of that culture of good practice around personal data within organisations to avoid inappropriate disclosures. Responding to information access requests on time, so that's another important one. But implementing a data protection by design and default approach is really important. That always comes up as an issue. So it's doing a data protection impact assessment if you need to. And just as I said, having that approach throughout an organisation to respecting the data that you handle and thinking about the consequences if something goes wrong and making sure that's right at the outset, so you're not got costly add-ons coming in at a later time.
It's all about culture, isn't it? It's all about and so in terms of the wider picture across Europe, so just this is data I think that I kind of finalized last week, so it's very up to date in terms of the country that, or the territory that's issued the most fines by a long way, Spain. having issued over 700 fines, and that's 36% of all the fines across Europe. And the closest to them are Italy and Germany, but quite a way back. And we're going to focus a bit more detail on Spain as to why that might be and how that looks and how it manifests. In terms of the top 10 fines across Europe, in terms of the value of the fines and the penalty notice, Ireland and France really stand out as issuing most of the highest fines, the high fines, predominantly because of the nature of the entities that exist within their territory. And that was something that was kind of obvious from the outset in 2018, is the countries that had the likes of Meta or Facebook as it was then, Amazon, WhatsApp and Google, all of those mega organizations residing in those territories would potentially present some real challenges in terms of the appetite to issue fines, Megan, I think probably, isn't it? It's about how high are you willing to go. We'll focus a bit on Ireland. I know Megan's got some insights on what's happening there. And then in terms of the least, those territories at the bottom have not regularly issued fines, but bearing in mind, the UK itself is only on about 13. In Spain, so the culture in Spain is to issue penalty notices and fines almost, and I might be wrong, but it almost feels like a kind of a parking ticket culture where you get a reprimand, you get a fine, a rap on the knuckles, and it's all about helping to maybe develop that culture where it's, if you breach and if you cause a breach, you're going to be fined, but not to the point where it's so costly the organization has to close. They have got big ones. They've got Google in Spain. They've had 11 fines over €1 million. However, 66% of their fines are under 10,000 euros. So that would suggest maybe they're targeting the small to medium sized businesses, and they're happy to issue fines even as low as 120 euros to a local home care homeowners association. So very different culture to what we've got in the UK. Ireland has its own particular challenges. It has those huge entities such as Meta, Twitter, WhatsApp, etc. And there have been multiple fines, so 5 fines, for instance, of Facebook in Ireland. And I'm confident in saying, Megan will correct me, that there were a lot of eyes on Ireland in terms of how it was going to deal with these guys.
Yeah, definitely. And I think definitely one of the decisions coming out from the supervisory authority in Ireland was challenged in the EU, and they had to overturn that and actually increase the fine, I think, from memory. But yes, there's certainly a lot of focus on Ireland just because of the nature of the tech companies that operate from there. Yeah.
Is it fair to say that some of these huge organizations would consider paying fines in relation to data privacy legislation part of the course, and something that they factor in, and they actually reserve money to pay these fines because they know they're inevitable?
I mean, possibly. And you would hope that these organizations want to get it right. And I think Facebook have just done, Meta, I should say, have done something recently around consent, so that they will now get consent of users in terms of behavioral advertising. So they are changing their practices. I mean, I can't speak for them, but I would hope that they do want to get it right. But I suspect they do have a bag of money there to pay any fines potentially.
I mean, one of my personal remits within ClearCom is on health care and health tech, and it's really interesting to see in Ireland, 6 of their fines have been on health-related organisations. I know that the first fine issued in Ireland was to TUSLA, the Child and Family Agency, so that's not something we've seen so much in the UK yet, but health and healthcare processes extremely sensitive special category data. It's a very attractive target for malicious cyber criminals, so it's interesting to see. We also have civil claims to factor in. So if you were to Google data breach, a lot of the initial responses that you returned, you'd see on the first 2 or 3 pages would all be about civil claims, and you as a member of society being given the opportunity to find out if you've been affected by a breach and how to claim. Personally, on a personal level, my partner and I were affected by a breach, a cyber attack on Emma Mattress, Emma Sleep, I think it's called, and there's a civil claim going at the moment for that. It's really significant, and if you're in the UK, you would argue that the balance is more in terms of the financial risk on civil claims as opposed to an ICO penalty notice. Probably the most significant in the news at the moment is Capita, suffering a cyber attack in March of this year, with 90 organizations reporting they're affected. So this is where we get into the realms of supply chain cyber attacks and organizations that are feeling the ripple effect of a cyber attack through a third party that they've trusted to act on their behalf. It emerged that Capita had left data unsecured online, and the thought is that it's around 4.5 million people that have been affected by that attack. First legal claims have gone in June of this year, so this will run 18 to 24 months for an ICO investigation, possibly the same or longer for a civil claim, Megan. I don't know what the average is, but it'll be around for a while.
Yeah, not quick.
No, not quick at all.
No.
And the thing we've always talked about, which is the huge problem that comes with any breach or cyber attack, is the reputational damage that is long lasting and residual, and in some cases never goes away. Some really interesting stats on screen. I'm not going to read through them. A couple that really stand out to me are the PwC research that nearly 90% of consumers will walk away and take their business elsewhere if a breach occurs. They might not do it immediately because they might be tied into a contract with you, but at the first opportunity, they will exercise their rights and they will go and find an alternative supplier. Customers, it's 2023, it's an internet age, will browse your reviews before doing business with you if there's a breach or history of not taking care of data carefully. And some organizations are repeat offenders, and it's all well publicized. That plays a big part in the immeasurable or measurable damage that you can have on your organization through breaches. In terms of the global impact of the GDPR, whether in Europe or UK, and how it's affected other countries, quite soon after the GDPR was in effect, we started hearing about the CCPA in California. Megan, can you just give us a bit of background on that and how it's kind of manifesting across all of the states of the US?
Yeah, and it's been really interesting, actually. And there was a question earlier, or I think we had it on the slide, one of those myths, does it matter about the size of the company? Well, yes, it does matter about the size in California, because there's 3 criteria you have to meet in terms of whether you are subject to that legislation. It's to do with your turnover and stuff like that, and type of data you're processing, etc. But all of those pieces of legislation, I think California is the lead, really, and the CCPA has just been amended, bringing in further rights for individuals. What we're seeing is legislation that incorporates similar rights to what we have in the EU and the UK, and also requirements on businesses in terms of what they must do around complying with it. Colorado, Connecticut are similar again. Virginia, I'm not across to a huge extent, but again, similar sort of rights seeing there. And then we've got all this other legislation to come. And I know they're talking about some national legislation that potentially is going to cover all states. I don't know how that will work in practice, but there's certainly a move over there. And also what we're seeing in America is a lot of which is not unusual, a lot of work across global transfers from the EU, UK to America, and American companies, are extending their reach to data subjects and consumers and clients within the EU and UK. So they need to get it right on both sides. They need to get it right in terms of the legislation they need to comply with, but a lot of them are subject to GDPR as well because of the global reach of GDPR.
Yeah, absolutely. And these, I guess, are the common themes across all of the different approaches across the states?
Yeah, so you'll see some similarities there to the rights that people have here and in the EU, quite substantial rights as well. So some control over sensitive data in terms of how that's processed, how they can opt out of selling or sharing their data, that type of thing, and similar ones to here: right of access, right to correct, right to delete. So we are seeing those come up. The burdens, or not burdens, the responsibilities on organisations there are quite substantial, and they're quite specific in terms of how they're laid out in the legislation as well. So they have to have a privacy policy on their website that covers specific things. I know that's quite similar to a privacy notice, but this is new for a lot of American organisations. There needs to be links. They need to keep it simple. The language needs to be simple. The legislation goes on very much about keeping it simple, and that's definitely my approach in terms of data protection as well. And you can't discriminate against someone if they've complained. That's actually written into the legislation. So it's quite an interesting approach, but lots of similarities there as well in terms of the states.
Yeah, and I guess that crosses over into the themes that we see across the world. I know that you, from a professional level, are managing at different times new sort of sets of legislation in sort of territories and nations you hadn't dealt with before. That must be really interesting to see the kind of common themes that you see.
It is really interesting. It is a complex world with any multinational organization, whether it's a charity that has offices all over the world or whether it's a big multinational conglomerate. So it is challenging because you do need to understand the state of the nation in terms of the countries in which you're operating. But what we're finding is a lot of countries now have some form of data protection law, either actually in practice or it's coming into force. We're seeing data protection supervisory authorities in play in many countries. Consent does come up as a legal basis, and often in the context of international transfers, that you have to have consent from people before you transfer data out of the country, for example. That's in Kenya. There's fines and sanctions, probably not to the level that they are here, but they're certainly coming into play. And, you know, we're seeing it being taken seriously in many different countries. And there's similar definitions, data subject rights, they're there. Some are not as substantive as here, but needless, you know, anyway, they're there. Some requirements around data protection officers in different countries as well, which is interesting. And as I said, international transfers. And that's a complex area in terms of mapping that out, particularly with multinationals, whether it be a charity or a big conglomerate. That can be a challenging exercise, making sure you've got all the right stuff in play, but also understanding how the legislation is fixed locally in different countries as well.
Yeah, and I guess that's one of the benefits of having a managed service provider in respect of data protection, because they would have, if you're an organization that is engaged in regular, constant transferring of data across different territories around the world, that they would have that top-down view, I guess, that helicopter view, wouldn't they?
Yeah.
I mean, in terms of what I've seen as someone who works in both cybersecurity and privacy, is a kind of an emergence of a hybrid approach to privacy and cybersecurity. And whereas maybe in 2018 we might see clients that came to us for a DPO, a data protection service, but maybe nothing else. We had other clients that would have some cybersecurity services from us, or would come to us for cyber essentials certification, for example. Now we see a real combining of both, and it's about the combination of behavior, culture, and technical standards and security, and increased awareness, and making sure that staff are aware of their role in respect of recognizing a phishing email, for instance, which wouldn't have been something we were talking about 5 years ago, probably. So in the early days, it was definitely a retrospective approach with little focus on actually developing best practice and a culture. COVID definitely has changed this. It's definitely now brought cybersecurity in particular to the fore. It's more of a fixed cost. Best practice in reality is a commitment to privacy and security, and probably no better person to quote in this respect is Einstein, who said a clever person solves a problem and a wise person avoids it. And that's absolutely about best practice and doing everything you can to not have to be dealing with an issue, and actually do all you can to avoid it. And that's when I think you get that kind of building of a human firewall from a privacy and a security perspective. So there's 5 good takeaway tips here, and it's a good point, and I should have mentioned this earlier. Today's webinar is being recorded and will be available on the Moore Kingston Smith website, and we will be providing you with copies of the slides. I'm conscious of time as well, so I might pick the pace up slightly here at this point. 5 pillars are all about evolving a culture, encouraging your employees to actually care about privacy, which will in turn support better security, reinforce that awareness of your staff, enable and empower your employees to challenge the hierarchy. So in terms of structures and hierarchies within organizations, the one subject area where we definitely need a flat structure with everyone transparent is cybersecurity and privacy. And you need to be able to measure it, because if you can't measure something, you don't know if it's working. We'll touch on COVID-19 and the impact that it had on privacy and cybersecurity. So immediately, organizations were sending staff home to work either completely full-time or part-time in that hybrid model as we emerged out of the situation. Most organizations didn't have a continuity plan to manage that. Those that did had probably never tested it, so this was the first test of their plan. We had all sorts of insecure IT setups in home environments, As Megan touched on earlier, organizations using tools such as WhatsApp when they really shouldn't have been for business purposes. And Interpol in the early part of 2020 recorded almost 1 million spam messages, huge amount of incidents relating to malware and malicious URLs, all related to COVID-19. And UK Action Fraud reported in 2021 some really scary stats in respect of the kind of fraud and cyber fraud and privacy-based activity that was causing terrible damage to organizations across the world, especially in the UK. A lot of the phishing attacks, for instance, the emails that were coming in were purporting to have access to items that were in short supply, such as hand gel, sanitizers, masks, PPE, all that sort of stuff. So I think what COVID-19 did was act as an accelerant to our focus on privacy and security. I think it just brought us maybe to a point in 2023 where we might have been ordinarily in sort of 3 or 4 years' time. What we'll do is we'll talk about ESG, we'll talk about AI, and then we'll try to answer some questions before we finish. And those questions we don't answer, we'll cover in the feedback after the event. ESG is a huge subject, especially in the world of accountancy at the moment. It moves organizations beyond regulatory compliance and more about behaviors. We've got 6 good steps here in relation to the fact that privacy and security are very much a core part of ESG. So from your experience, Megan, this I think is, we were talking before, this is about tangible steps as opposed to just a theory of privacy, isn't it?
Yeah, and it is. And a lot of this is built into data protection and some of the requirements. But broadly speaking, it's around that culture that Rich has referred to. And that's what I often talk about. It's that getting it right from the outset, making sure all your staff are fully trained and aware of all of this. Only processing data that you need. Don't be hoovering up data from all over the place just in case or because you can. You need to think about the purpose for processing. So it's about taking a bit of a step back and thinking about actually what are we doing? What do we need to do? What's necessary? And also thinking about it ethically as well, although that's not required and really part of the framework in terms of data protection, but it actually sits there as part of what you're doing because you have to be fair with people as well. So that sort of forces you to think about ethics.
Yeah, minimization for me has always been something that if you always focus on minimization, you're going to probably make better decisions on a daily basis. So how would you sum up minimization as a principle?
It's about only processing what you need to process and not being excessive, or, as I said, not taking and hoovering up data from all over the place just because you can, as being keeping the minimum amount of data that you need for whatever it is that you're processing for.
So the next 5 years. So we've got just about 5 minutes left. So what are the likely changes and evolution we might see? So we've touched on the new bill in the UK. Megan, are you happy to sort of briefly talk about the adequacy decisions? Very briefly.
So the EU Commission has just recently determined that the US privacy framework is adequate. So that means if an US organization is signed up to that framework and there's a fee and there's a process involved, then organizations in the EU can rely on that to transfer without having to do any of the other things like impact assessments, etc. The UK will join that as well, but they haven't done we haven't done as yet. That's meant to be coming towards the end of the year, which again, if the US organization is signed up to the framework, we can transfer data from the UK to the US without worrying about any of the other safeguards. So it makes it more efficient, effective. It may be challenged, we don't know yet, but at the moment, that's what we have in play.
Yeah, AI. I think we'll touch on AI in a bit more depth. Although we're not doing anything from a legislative perspective in the UK at the moment, the EU is definitely trying to grasp this while it can. And I think the whole theme here it seems since the turn of 2023, everyone is talking about and concerned about AI and its impact on us in our lives and in business. And the EU is kind of responding, I think, to what is the surge of AI tools, and ChatGPT has probably been the driving force for this. It's really kind of come to the fore, and how quickly it was adopted and the volume of individuals that were suddenly using it. And the EU wants to respond to this quickly and make sure that the kind of tools that are being released to market are regulated, and that those who are developing and deploying this stuff are regulated and that where they're defined as high risk in any of the 8 areas we list on the screen now, that they have to be registered in an EU database. And I think, Megan, I'm right in saying that this really is speeding on. It could be adopted into law 2024, 25?
25, yeah, we're looking at. So yeah, it's moving through its EU processes as we speak.
Yeah, so it's really significant, and but everything kind of makes sense in terms of the kind of data that we're talking about from a privacy perspective, such as biometrics, for instance. That really should be regulated and it should be controlled. It's the sort of information that is permanent. It's not something you can change. If you can't change your fingerprint or your retina, so once it's out there forever. So definitely needs to be regulated. So we've got a couple of minutes, I think, to answer a couple of questions. Megan, are you happy to pick out any that?
Yeah, I'm just looking at them now. And we will try and answer these separately outside of this as well, in terms of sending you something. So someone's asked, there's been a few questions about cookies. So for example, how do you get consent for cookies in marketing emails? So that is a really good question, and it is quite tricky. But what I would say is, when you get individuals to sign up to receiving marketing emails from you, which should be based on consent if it's members of the public, at that point you can ask them, do you consent to us using tracking pixels or whatever you want to call them there? And the most important thing, I think, is having an opt-out option or within any email that goes out as part of any marketing communication, so people can opt out or unsubscribe to receiving those. But that's a really good question. It is a question that a lot of clients are asking us. Someone's also asked, should all websites have a cookies policy? You don't necessarily need to have a cookies policy, a separate cookies policy. You can incorporate it into your privacy notice or your privacy policy on your website. That's really a choice for you. The most important thing is that people can get access to that. If you do have a separate cookies policy, you'd have perhaps a link in your privacy policy to take them to the cookie policy if you have it separate. But you don't need a cookie banner if you are only collecting necessary cookies. You only need that cookie banner consent mechanism in place if it's non-essential cookies that you're using. So it's worth checking your website in terms of whether they are actually collecting analytical cookies, and then you can make a decision then on how you need to approach that, because often it's hidden as well, and it's really just the IT people or the website people that know that the cookies are in operation. So it's worth checking your websites.
We've got time for one more quick one, I think.
Yeah. Let's have a look. Rich, I think there might have been a typo on one of the slides around the Clearview fine.
Oh, okay, I'll find that. Yeah,
we'll amend that.
I will check.
Let's have a look. Right, so WhatsApp, there's a question about WhatsApp, and it's an interesting one. We have issued some, for the clients we deal with, we've done a policy around the use of WhatsApp. And this recent case this week has just highlighted that there is a risk with using WhatsApp. It's not saying don't use it, and we certainly don't say that. It's a useful tool for colleagues to interact with each other. But there are risks with that. It's off the corporate record. It's really out with the governance and oversight of the organisation, and people can potentially request data that might be being processed on those WhatsApp chats. So you need to be thinking about that in terms of risk for your organisation. And the ICO did a recent report on the use of WhatsApp across government during the COVID period, and were quite scathing.
Brilliant. I think we're pretty much at time. So we've had about 30 questions. So obviously it was never going to be possible to answer all those questions live. We will respond to all of those questions in the follow-up content, and you will all receive a copy of today's slide deck. We will check that fine on Clearview AI, and we'll make sure that's right. You can reach out to Clearcom via our direct email address, which is info@moreclearcom, or please feel free to contact Megan and myself direct. Our email addresses will be, I'll include them in the slides as well. Visit us at moreclear.com. Thank you so much for joining us today. The webinar recording will be on the Moore Kingston Smith website very soon. So thank you very much. Enjoy the rest of your day, and see you all again soon. Thank you.
Thank you.